For the successful bidders specific. He might have just come online now, apparently. There he is, yes.
Okay.
How's it, Joe?
I'm well, thank you. Everyone else is fine?
Good. Thank you. Morning, Josh.
Morning, Mr. Lukaitobi. How are you?
Fine. Thank you, Josh.
Good. I think we're just waiting for Mr. Khoza, are we? Is Mr. Khoza with us?
Morning, Judge. I'm the inspecting attorney. He's trying to log on. He was a bit struggling. I think he was on a wrong link. But I've sent him the correct link.
All right, good. So as I understand it, there's just the three of you. It's Mr. Ngosani for the applicant, Mr. Lukaitobi, you for everybody except 13 and 15.
Indeed, my lady.
Is that correct? Good. All right. So once Mr. Khoza joins us, then we can get underway. Is there any representation for the fourth respondent? Do you know?
My lady, I think that's my client.
Is that?
No.
Oh, is it?
Mall, isn't it?
Oh no, sorry.
That's Corey Moore.
Corey Mall.
It was Miss Corey, I think. Sorry, my lady.
Because I see there's no heads. I'm not sure, Mr. Musani, do you know? Because I see from your heads that you're not proceeding against the fourth and the 18th respondent. Am I right?
Our list is over. Yes.
Okay. All right. So I presume that there won't be any representation for them today. Okay, good. Are we still waiting for Mr. Khoza?
Yes, my lord. We're waiting for Mr. Khoza. I've also sent him the link via the cell phone as well, via the WhatsApp, because he seems to be on the wrong forum, but we are trying to correct that.
Okay. All right. Well, we'll just give him a few minutes, I suppose. Got any news yet? And whether Mr. Koza has been successful or has got now the correct link?
My lady, can we ask just for 5 more minutes? He seems to be struggling. I don't know what is the issue, but I'm with him on the phone as well, trying to find a solution. But if you can maybe allow us 5 more minutes, we should be fine.
Should we log off and log on again, or what do you suggest?
No, yes, I want him to just switch off his gadgets and restart them from.
There was a lot of feedback on that. I didn't catch the last bit. You said you were trying to get hold of him.
No, I'm with him on the phone. I'm trying to assist him log in. So I'm with him on the phone on the one hand. So I was asking just for 5 more minutes.
My question was, should we all log off and instead of sitting around and then we log on again in 5 minutes? Is that what you're asking?
Oh, he's in now. He's in, my lady. He's in.
Right.
Okay.
A difficult connection this morning. I apologize, my lady.
Okay. All right, Mr. Koza, so you're with us.
I am.
Okay. Okay. Now I see Mr. Nsani has disappeared.
Judge, I can see myself on.
There you are.
Yes.
Yeah. You've taken the spot on my screen that was occupied by Mr. Nlukaitobi. He's disappeared from view, but I can see that he is logged on. Yes. I just want to, good morning, gentlemen. I think we can carry on now that our technological glitches have been sorted out.
Yes,
right.
Apologize.
I think for the purposes of the record, if each of you, starting with the applicant, can put yourselves on record, please.
Thank you, my lady. I appear on behalf of the applicant, Jay Musani SC, together with my learned colleague, Ms. Reshma Athmaram.
Thank
we
you.
instructed the state attorney.
Okay. Thank you, Mr. Musani.
Thank you, my lady. I appear together with Mr. Ramukhale for the 3rd, 5th, 6th, 7th, 8th, 9th, 10th, 11th, 12th, 14th, 16th respondents. These are we've referred to in the heads as the successful bidders.
Yes, thank you, Mr. Nlukaitobi. Mr. Koza?
My lady, I represent the 13th and the 15th respondents.
Good, thank you. Good, that's all on record now. The way forward, I've read the papers and I'm proposing that you don't repeat everything. But before we get there, I just want to place on record, Mr. Nwasani, that the applicant is no longer proceeding against the 4th and the 18th respondents. Is that correct?
That is correct.
Okay. Then with regard to the joint application, would it also mean that you're not proceeding, you don't want to join the 28th and 29th respondents?
That if this is the same persons, yes.
Yeah, well, those are actually, I know you said that those were the liquidators of the 4th respondent, but that's not actually correct. That is those were the liquidators of the 18th respondent.
Yes, to that extent, of course, yes.
Yes. So then the joint application will not apply in respect of the 28th and 29th respondents. Okay.
Yes. My lady, before we proceed with any further matters, over the weekend, I received a notice of amendment that the successful bidders brought. I assume that Mr. Koza also associates himself with the application, but there is an amendment to the constitutional challenge. I don't know if that's come to your attention, my lady.
No, it hasn't.
the constitutional challenge that's now come to the fore is a frontal challenge to Section 8.2a. I believe that Mr. Nkukaitobi might be in a better position to explain that to you.
Yes. Should I? Thank you.
One moment.
Thank you.
Just give me one moment, please. I'm just going to note that. All right, so you say it's a frontal challenge to Section 8.2a of the Act.
Yes. Yes. Judge, you will recall that on the last occasion at the case management, your sister was of the view that because our application did not directly implicate Rule 26 and Regulation 52B, that in those circumstances, any suggestions of a stay would have to be founded on a formal application. We didn't prosecute a formal application. That situation might have changed, and I believe Mr. Nkukaitobi would be better placed to give you the highlights of that.
Thank you, Mr. Nkukaitobi.
Yeah. Thank you, my lady. I'm grateful to my learned colleague for raising this upfront, because we would have raised it in response, which probably would not have been most prudent. Now, my lady, you will recall that what this application is about is under paragraph 2.1 of the notice of motion, which is at case line 013-3.
Give me one moment. I've got to be swiveling around to try and get all these papers in front of me. So
I can imagine.
2.1 of the notice of motion, you say?
Yes. Now, that is what is at stake. It says the 2nd to 16th and 18th respondents be and are hereby interdicted and restrained, either directly or through any third party, from dealing in any manner with the property listed in Schedule A annexed to this order. Now, those are the properties belonging to my clients. Now, the substantive basis now, and I just need to explain this a little bit, because I was really worried with the exchanges at the case management meeting, because it seemed that there was a misunderstanding about what is going on. Now, if you want an interdict is a remedy. It is not a right. If you want an interdict, you must show a right, either on a prima facie basis if it is interim, or on a clear right basis if it is final. But the interdict and the right are separate requirements. Now, Section 8.2a of the SIU Act confers.
Sorry, just give me one moment. Just give me one moment. There we go. Is that better? Sorry, I believe I wasn't appearing too clearly on the screen. Okay, I think we sorted out now.
Yes.
Thank you.
Oh, yes.
Sorry,
you were.
Mr.
I think it was cutting.
Yes.
Your lower lips, my lady. So, but now nothing is cutting anymore. Now.
Thank you.
So this is a basic rule, and I don't have to persuade your ladyship about this. An interdict is a remedy, it is not a right. In order to get an interdict, you must show a right on a prima facie basis or a clear right on a final basis. Now, Section 8.2a of the SIU Act is the remedy of an interdict. It is not the right to an interdict. The SIU always had to show a right to an interdict. What we understood the right that they were relying upon was the right set out in the rules and in the regulations. Rule 26 of the SIF, the Special Tribunal rules. That's the rule that confers the entitlement to restrain the use of property. Now, there was no challenge to that rule. We then brought, on the 27th of May, we brought a constitutional challenge to the rule. That is pending.
And that's the constitutional challenge you spoke of, that's in the High Court at the moment.
That is in the High Court, yes. That is pending. And then secondly, there is Regulation 5 of the Special Tribunal Regulations, which explains the ambit of civil proceedings. Now, that too, Regulation 5(2)(c) and Rule 26, which are the substantive basis for the granting of an interdict, which is where you show your prima facie right. Now, both Regulation 5(2)(c) and Rule 26 are pending before the High Court as constitutional challenges. They were brought 2 months ago. My learned friend and I must work around the timetable to expedite those matters. Now, what that means is that the substantive basis on which your ladyship can authorize a deprivation of property, which is what paragraph 2.1 is about, is the subject of a constitutional challenge. Then we come before, the SIU then says, all right, until that constitutional challenge is finalized, let's postpone the proceedings, because there is no point in your ladyship granting an interim forfeiture order, which is really what paragraph 2.1 is about, or an interim interdict to restrain the use of property, when later on it will be shown that the rule and the regulation that authorizes the interim forfeiture order would be unconstitutional, because that undermines the rule of law. That is what they said on the last occasion. I then said that was okay, we agree with that, but we must expedite the constitutional challenge so that we don't delay these proceedings unnecessarily.
Therein lies my problem. I don't know how long it would take for this constitutional challenge to reach finality and for us to know one way or the other. And my difficulty then is what happens. Does that mean all proceedings of the special tribunal simply come to a halt? We must stop working then. You know, for instance, if you had to challenge a provision of the Superior Courts Act, read with the rule, uniform rule, whatever it is, does that mean the court must stop dealing with matters in that respect? You know, that's where my problem lies. Perhaps you can give some clarity on that.
Yes, my lady, that typically, you know, the problem is the following, actually. It goes back to another constitutional issue we have. If the tribunal was a court equivalent to the High Court, the constitutional challenge would have been brought here before the tribunal, and the tribunal would deal with it there and then. It would deal with the constitutional challenge and the interdict at the same time. But until the constitutional challenge has been finalized, there can be no finality on the interdict itself. And this is not the first time this has happened. It has happened in the Equality Court context, where under Section 10 of the Equality Act, there are provisions for hate speech, but Section 10 was under challenge. It was said that pending the determination of that, constitutional challenge, the Section 10 cases, some of them were held over, some of them, depending on the degree and the nature of the agency and whether they could be carved out of the section, could be held in abeyance. Once that challenge was finalized by the Constitutional Court, those matters were prosecuted afresh. So that is what typically happens in any event on these constitutional challenges. Now, the problem here that we have is that we cannot bring an application for a declaration of constitutional invalidity before the tribunal, because the tribunal is not established as a court with the same powers as the High Court. Now, that question is currently pending before the Constitutional Court. It was heard about 3 months ago in a different matter about whether or not the Special Tribunal can act like a High Court. The Special Tribunal itself has delivered a judgment in which it says it can function like the High Court. But that judgment conflicts with 3 other judgments from the High Court, which say the Special Tribunal cannot function like the High Court. And that is why the Constitutional Court has entertained the application, and it is pending there. So that's the proposal we would make, is that at least insofar as this specific case, where the issue is raised squarely, there is a stronger justification for pending the case until the constitutional challenge has been finalized.
Okay, so then it means I misunderstood, what was said at the case management meeting. I was given the impression that the constitutional challenge related to the tribunal's ability to make orders of forfeiture, not preservation orders or interdicts. So that was I got the wrong end of the stick there, did I?
Yes, we challenged the entire basis on which preservation and forfeiture. And now we've made it clear in the amendment that even an interdict which has the impact of restraining the use of property is the subject of challenge. Let me just read out to your ladyship. We've got a new paragraph 2 capital A, which says, declaring that section 8.2a of the SIU Act does not confer a power on the special tribunal to issue any order that has the effect of interfering with a party's property rights, including but not limited to an order depriving a party of any property, an interdict and or restraint against the use and enjoyment or right to deal with property, the preservation and anticipation thereof, the authorization of the confiscation of any property to place under curatorship or otherwise interfere with a party's property rights. So if we are successful in that relief, the special tribunal continues to grant interdicts in the normal course, and it continues to grant reviews in the normal course. But it's the interference with property. Now, your ladyship, I've seen your ladyship in the criminal courts. You are very familiar with poker. Now, when a legislation is designed to interfere with property, it will be in the statute itself, and it will be explicit. Why? Because property is a special thing that is specifically catered for in section 25 of the Constitution. And in section 25(1) of the Constitution itself says there should be no deprivation of property unless it is in terms of a law of general application. And even that law must specifically empower a court to interfere with property. Now, the problem that we are facing here in this case, and it's probably right that we are debating this in open court rather than in a private sitting. The problem we have here is that the SIU Act nowhere authorizes the deprivation with property at all, whether on an interim basis, whether on an interdict basis, whether on a final basis, whether on any basis. The SIU Act just does not deal with property. We find the provisions dealing with property in the regulation and in the rules. And that is why challenge number 1 to the High Court is the rules and the regulations are ultra vires because they are granting the special tribunal power that is not granted by the legislation. And that is why we've also said section 282A is just a general interdict. It is not a power to deprive a party of use, exploitation, and enjoyment of property, because cases like Prophet clearly state that if you want to interfere with section 25(1), you've got to do it in a law of general application. It must appear in the Act. Now, so that is what the constitutional challenge is about. Now, this is where the dilemma is. If we could get that constitutional challenge out of the way in a week or two, we launched this on the 27th of May. So it's not a delay on our part. 27th of May, we launched it. It's June, July, 2 months have gone by. We would like to get that expedited and thereafter to come back to this case and say, what are the powers of the special tribunal to order an interdict that deprives a party of the use and enjoyment of property? This is not the same thing as challenging the power to grant a review. We grant that the power to grant a review will continue. The issue now is paragraph 2.1 of the interdict. So that is why we say the most pragmatic thing is to postpone the hearing. Of course, we, my learned friend and I, need to work on getting an answering affidavit from the SIU on the constitutional challenge. Maybe the SIU is not interested because that is a challenge against the president, not against the SIU, because it's the president who has, and the Minister of Justice, they are the ones responsible for the legislation. But they're not answering the affidavit, the application. The president is not filing an answering affidavit. The Minister of Justice is not filing an answering affidavit, but they are the parties responsible. So they are constraining the SIU. It's got one hand in and another hand held behind their back because the politicians that are supposed to defend the legislation, after 2 months, have done nothing. So we would ask as a first request, if your leadership rejects it, fine, we will deal with the matter on the merits. But we would ask in all seriousness that this matter is adjourned, the constitutional application is expedited, and we come back, even if your leadership says, I'm giving you 3 months, if you don't do it in 3 months, I'm proceeding. So that's what I wanted to say in limine, my lady. I don't know what my learned friend's instructions are on this point, but I know that it was their attitude on the last occasion, which we were, I think, mistaken in not supporting. But I think now it's necessary for us to take up the cudgels on that issue. Thank you, my lady.
Thank you. Before I give Mr. Musani a chance to respond, I think I must hear Mr. Khoza and see what he has to say, and then I'll give Mr. Musani a chance to respond to both. Mr. Khoza?
My lady, I hear my colleague's latest challenge, which we do not have any objection to, and even the suggestion to postpone, we don't have any objections to it. Obviously, we were under the impression I only received it this morning as it was being addressed here, but I didn't really have a chance to have a look at it beforehand. But I've received instructions that we don't have any objections to it at all. It makes practical sense what Mr. Toby is suggesting about postponing it and having a hearing on the issues in these proceedings maybe later on. The only issue, obviously, is that the matter was raised partially at the last case management meeting by the applicants, where they were seeking the stay of proceedings on the basis that there is this constitutional challenge. The 13th and the 15th respondents are not necessarily involved in the constitutional challenge. They are only involved in these proceedings. They're only interested in the interdict and to get the interdict dismissed, this application dismissed. So therefore, we don't have a view about whether or not we should proceed. The only issue is about cost of these proceedings being delayed and coming here and having to postpone at the last minute when we're prepared to go ahead today. But that's not an issue. It can always be dealt with when we return to this court, if this tribunal is of the view that we should return at a later date.
Okay, thank you, Mr. Khoza. Thank you, Mr. Musani. Your reply and your thoughts on what's just been said.
Lady, Yes, my lady, paragraph 7.2.4 of the answer, that's at 013318 of the answering affidavit.
And which answering affidavit?
The Mr. Nkaitobi, the successful bidders answering affidavit at 013318. And paragraph 40.
Right. Just give me 1 moment. Para what?
724.
Okay.
And para 40. Both foreshadowed the this very question. And if you look at our answering affidavit, our replying affidavit, we didn't really deal with that question because when we had filed our reply, those papers that were contemplated in the application had not come to fruition. We hadn't received them. So there is the embodiment in the answering affidavit of this type of stay. Of course, it's not a formal stay application. The cases don't require a formal application because this is a matter that's within the inherent jurisdiction of the court. The rules don't specifically make mention for a stay application. Of course, it is desirable for there to be a stay application. But in this case, the challenge as it was manifested initially did not directly implicate Rule 26. This application, or certainly we didn't rely expressly on Rule 26.
I think you made that fairly clear later on, although I must say, I share the view of the respondents at that stage. Initially, I also thought that, you were relying on Section 26.
Well, the application, our application does make reference to the language. And so there is the argument that it is implicated, but there's no express reference to it. And that is why on the last occasion, I couldn't advance any significant material submissions on the question. But I think that has now changed when this frontal challenge was delivered over the weekend. And the question ultimately is really whether it is both practicable and whether it's in the interest of justice, because that's the test that the Constitutional Court raised in the Prince judgment. And I'll give you that reference momentarily. So those are the two key features, and it's ultimately a question of ensuring that state resources are not wasted in litigating over a matter only for all of that to ultimately be undone. Now, this is not a case where every single interdict is implicated. It's only these particular ones that are implicated. Faced now with a full frontal challenge where the very basis of our application is implicated. In this regard, might I refer you to our founding papers? The specific provisions that we rely on can be found in paragraph 68 of the founding affidavit. That's at 01326 of the case lines.
Yes. Oh, by the way, I strongly recommend you go back and look at the numbering of the paragraphs in the founding affidavit. That needs to be corrected. It can be a little confusing. I see that the answer was very politely just referred to exactly the paragraphs in your founding affidavit, just to prevent confusion. But look, for instance, I think it's 47, 48, and then further on as well.
Oh,
that's not serious for now. Yes, you were saying that paragraph 68
Yeah.
deals with this, specifically with that provision.
Yeah. So in paragraph 68, where we deal with the applicable legal framework, we rely upon section 8.2. Now, the question that's got to be determined ab initio is whether the challenge as it is framed, as it was read out to you by my learned friend, whether that challenge carries with it a reasonable prospect of success.
Yes.
You've heard my learned friend tease out the argument for why he says his clients say it's unconstitutional. We have not put up an answer to the constitutional challenge. And my instructions are that in due course, if we do put up papers, or when we put up papers, we are not going to object to the amendment. This new amendment will deal with those matters in due course. So at the moment, you don't have our version under oath, our attitude under oath. I can only tell you that I'm advised that the SIU intends to oppose. The details thereof are matters that are matters to be dealt with in due course. So unfortunately for me, you only have the one version, one iteration of the constitutional challenge. I can't, at this point, tell you the chapter and verse, but generally speaking, I'm told that the SIU intends to oppose it and will rely upon the argument that the SIU Act is a law of general application, and that the particular section is saved. But I don't think that it's necessary for us to debate the precise contours. At a prima facie level, it is a matter that raises a valid constitutional question. It is in an extant application. You only have one version at the moment, and I cannot, in all conscience, advance the argument that you should continue with these proceedings in the face of that state of affairs. Yes, the papers were issued on the 30th of June and served on the SIU on the 6th of July. Its answer would be due on the 3rd of September, 3rd of August, I beg your pardon. My clients have asked for time. There has not been as yet an answer to that. I believe that my learned friend is quite correct that he and I will, in the course of the next few hours, try to work out the modalities on how we can expedite the constitutional challenge, because I believe that is where we must focus our energies. That is where state resources must be directed to. And of course, I don't know what the ministries and the presidency's answers are going to be, and I don't know whether they've also asked for permission for an extension. I also don't know what the special tribunal's position is, because it also is directly, it is a party to those proceedings, and I don't know what the special tribunal is intent on doing. And that, I think, for me, is another source of concern. It seems to me, at least, that it would be inimical to the interests of justice and to the constitutional framework that you have for the special tribunal, whose powers are challenged, to simply brush aside the frontal attack on the basis of expediency, on the basis that there's no formal written application for a stay. In the Prince judgment, there was no formal application for a stay. What happened was that, you recall, Mr. Prince wanted to set aside the cannabis legislation. There were several other pieces of litigation going on in different parts of the country. And the Constitutional Court there essentially asked the parties to make submissions to it. And what it did was to do the kind of exercise that my learned friend spoke of. What it did was it addressed the purpose behind a court exercising this inherent power. It highlighted the fact that the idea behind this power is to prevent a multiplicity, a duplication, and ongoing litigation over something in the face of a constitutional challenge. It concerned itself with the nature of the challenge. In that case, in the Prince case, of course, the challenge was primarily over the right to privacy, but it also implicated other rights that were in the Constitution. And the Constitutional Court there noted that these were matters of public importance. They had far-reaching consequences for the citizens and for international law, because our law was in that regard, in regard to cannabis, was to a large extent out of sync with the way the rest of the countries in the world were going. And it also considered the prejudice to the respective parties in that case. In my case, we are, of course, accused of delaying. Not something I can close my eyes to. And I cannot, in all conscience, now advance the submission that, notwithstanding the accusations against my clients about their delay, that this application must take precedence over the constitutional challenge. It seems to me that an organ of state must advance the constitutional values and must seek to promote those, especially where it is directly challenged. All the more reason for it to adopt a stance that promotes constitutionalism. In this case, and with this constitutional challenge, it is impossible to deal with the application on the principle of constitutional avoidance. We can't avoid the constitutional challenge because it is a direct frontal challenge. You will recall that Her Ladyship, Madam Justice Matibe dealt with that application on the footing that it didn't directly implicate or refer to the sections. It seems to me that the same answer should yield now that the section is directly implicated. Seems to me incorrect to say, I'm not going to grant this, I'm not going to entertain the stay because it doesn't prima facie implicate the sections that are the subject of the constitutional challenge. But now that the constitutional challenge is a direct one, I'm going to ask you to bring a formal application. I'm going to ignore that this is at least in part embodied in the answering affidavit, and I'm going to ignore the fact that there is no answer as yet to the constitutional challenge. It would have been a different thing if I was able to come to you and say, well, we filed our papers, this is our answer. We haven't done so. So I'm really left with no real ammunition to oppose the suggestion that at a practical level, what should happen is that we should be focusing our energies on the constitutional challenge, direct state resources to that issue, get it expedited, and insofar as this application, it should be pended until this constitutional challenge can be dealt with. It can be expedited and arrangements can be made with the judge president for this application to be heard, because if it is dealt with correctly, it disposes of quite a number of, potentially may dispose of a number of matters before the special tribunal. It may give rise to a change in the legislation, and it may have a significant consequence on this application. There is another aspect that I'm concerned about, and that is if a constitutional entity, an organ of state, is told about a constitutional challenge and it presses ahead with an application without having filed its answer to the constitutional challenge, presses ahead, obtains the relief, then deals with the property consequentially, that may open up the possibility of damages claims. So one must be mindful of simply adopting the kind of posture which says, go ahead, disregard the constitutional challenge, even though we don't have an answer. I think our failure to answer, to me, is quite pivotal. And it's for these reasons that I think that under the present circumstances, I cannot advance intelligible submissions to prosecute the application. I'm driven to agree with Mr. Ncukai Tobi, my learned friend. I think the circumstances have changed from the last occasion. My clients are not, of course, happy with all of this, but it is a reality that we're faced with a direct challenge now, and I can't advance any submissions without these at least having been foreshadowed in papers. So it seems to me that the proper thing to do in the exercise of your discretion is to consider whether in all the circumstances it is appropriate for you to determine the application in the face of the recent challenge and what the consequences of that are.
Thank you. Are those your submissions, Mr.
Yes,
Nsana?
my lady. Yes, my lady.
Okay. Thank you. Any reply to that, Mr. Ngukaitobi? You're muted.
Thank you, Melissa. Normally, I only have one point because there is a substantial overlap with all three advocates. The case of Fisher and another versus Ramahlele and others, which is a 2014 judgment of the Supreme Court of Appeal. It comes into this issue is where the parties agree for their own reasons about a course of conduct in a case. What is the role of a judge in that instance? Now, it was slightly different in that case because the judge, it was Judge Gamble, had decided to introduce his own issues into the fray and then proceed to decide those issues. And he was severely criticized by the Supreme Court of Appeal on the basis that the parties come to you, they are represented by senior counsel. They explain the course of conduct. One of them is a state entity, another is not, but they explain what the position is from their perspective. And then you then decide as a judge that I want to do it my own way. Paragraph 14 of that judgment is a salutary reminder about the caution to be exercised in those instances. It says, it is not for the court to raise new issues not traversed in the pleadings or affidavits, however interesting or important they may seem to it, and to insist that the parties deal with them. The parties may have their own reasons for not raising those issues. A court may sometimes suggest a line of argument or an approach to a case that has not previously occurred to the parties. However, it is then for the parties to determine whether they wish to adopt the new point. They may choose not to do so because of its implications for the further conduct of the proceedings, such as an adjournment or the need to amend pleadings or call additional witness. They may feel their case is sufficiently strong and it stands to require no supplementation. They may simply wish the issues already identified to be determined because they are relevant to future matters and the relationship between the parties. That is for them to decide and not for the court. If they wish to stand by the issues they formulated, the court may not raise new ones or compel them to deal with its own matters. And then the paragraph 15, this last point is of great importance because it calls for judicial restraint. So we simply ask your ladyship that where you have the SIU saying for the second time in less than a week that let us address the constitutional challenge first, and the judge going behind that and saying, I want the clients to speak, that is outside of judicial restraint that has been specifically called upon for by the SCA. And where you have three advocates saying this is the approach that should be followed in a matter, it should take very special circumstances for a court to take its own line and say, as far as I'm concerned, this is the approach that should be followed. Especially, my lady, in a case like this, because, one more thing that Mr. Musana said, which I need to really emphasize that he's absolutely correct. Especially in this case, my lady, where, if I can just give you the timeline, this is a 2017 tender. 2017, January 2017 tender. The SIU's instruction to investigate came, I think, in August 2020. The SIU's decision to review came on the 7th of August 2020. And the proceedings themselves were instituted in July 2021. So this is not a case where the interests of justice cry out for an immediate intervention. This is a case where for 3 years, it's been proceeding leisurely. There have been numerous delays. The payments were made, and my clients say, we've spent the money. And in those circumstances, there is no immediate urgency that says this is a case where I simply cannot allow an adjournment because it is so pressing and it is so urgent that it must be dealt with yesterday. The only issue that then arises is how does your ladyship make sure that the work of the tribunal is not disrupted? But we are not asking for the postponement of each and every case that deals with these sections. We are asking for the postponement of this case. If another party comes with its own case, with its own facts, it must justify its own case and its own facts. It cannot now tag along because a postponement does not create precedent. It's a postponement of the case on the unique facts of the case. So the next party that comes must sort out its business, and it cannot now ride on the coattails of my client because my client was the first mover in bringing the constitutional challenge. So any other opportunistic application that comes after this would have to be dealt with on its merits. And if the constitutional challenge that they bring is bad, of course, the court must say, we think your constitutional challenge is bad, we're proceeding. If you somehow win in due course, well, so be it, we will deal with that. Then the other cases, I asked my colleague, my junior, to check the position that has been taken in relation to constitutional matters.
Before you go on, sorry, Mr. Ngokaitobi, just give me the reference to Fisher's case, please. It's 2014.
Oh, yes, sorry. Fisher is a 2014 judgment. Sorry, it's 2014, volume 4, SA 614. SCA, and I was relying at paragraph 14 and 15. It's a judgment of Justice Wallace. So I've asked my my colleague to check what the practice has been. I just remembered actually the case I ran on behalf of Mr. Malema, where he was criminally prosecuted for an unlawful land invasion. The NPA in that case agreed to adjourn the prosecution, which is even stronger than an interdict because it's a criminal prosecution for land invasion until the Constitutional Court decided the constitutional challenge. And of course, Mr. Malema won the constitutional challenge. And they withdrew the prosecution thereafter. So often, even though today you don't see what the future trajectory of the case, often that is why there should be judicial restraint, because even if anyone thinks that my client's challenge is frivolous, because the NPA in that case accused us of bringing a frivolous challenge. But we won the case 10-1 at the Constitutional Court in the end. And the NPA, though, had taken a responsible thing to wait until the constitutional challenge has been determined. And so that's the approach we would recommend to your ladyship to follow in this case. Thank you, my lady. I have nothing further to add.
Thank you. Mr. Kosa, do you have any closing comments? Mr. Kosa?
Nothing from my side, my lady. I concur with you.
Yes. Okay, I think I need some time to just consider this. I'd like to deliver the ruling today, but I'm at a distinct disadvantage in that I have not been privy to the papers in the High Court, the constitutional challenges you've referred to it. I've not seen them, and I simply was relying on what was relayed to me at the case management meeting, that it was a constitutional challenge dealing only with the power of the tribunal to make forfeiture orders. Obviously, it goes a lot deeper, but if the SIU in this matter is relying on Section 8.2, and there's now a direct challenge to that, it obviously changes my understanding of the situation as well. I just need a few minutes to gather my thoughts, think about this, and then perhaps in an hour or so we can reconvene.
That is in order, my lady.
Thank you, my lady.
My lady, might I just inquire? My lady says that my lady does not have the at least the notice of motion it has been served on everyone. Does Milady wish for those papers or just the notice of motion to be sent to you?
Well, at this point it means reading, and as I say, I rely on what all of you, and I can't think that three of you will be wrong in what you say is the content of the challenge, and I accept what you've said. But for me, the biggest thing, and I haven't seen the amendment that came in over the weekend, but if you are relying on Section 8.2 for this application, and that is now under challenge, then it puts a lot of constraint on me at this point to move forward. And I always respect constitutional challenges, and that is what we are guided by. And my prima facie view is that if that is a constitutional challenge, it involves a public body, it involves the public interest and public funds, then we must act accordingly. And consider that. That's my prima facie view. But I just want to gather my thoughts around the submissions that you've made, and then perhaps in an hour we can reconvene.
As you please, my lady.
Thank you. Good, Jens.
We'll stop then and log on again, I think.
Yeah, I think let's do that.
Morning. Are we all on board?
My lady, we are and my team are back.
Okay. We're waiting for Mr. Musani.
Indeed.
Okay. And I see is that the SK Mr. Koza?
I am here, my lady.
Good. So we just wait for Mr. Musani and then we're ready to go.
Yeah.
Yeah.
Mr. Musani, you've joined us.
Yes.
All right.
Apologize.
Thank you. Yes, I've had an opportunity to just go through your submissions again. And it would appear that since the case management meeting on the 21st of July, there's been a change. At that particular case management meeting, the president of the tribunal conducted the meeting. I think at that stage, the SIU indicated that this application should be stayed because of a constitutional challenge mounted by the respondents, whom in the papers have been referred to as the successful bidders. The president then directed that a formal application for stay must be brought because it had been indicated to her at that stage that the SIU was making an application for a stay of proceedings, and she was not satisfied that enough was put forward for that. But what's happened, the matter when we commenced this morning, I was advised that there's been an amendment to that notice of motion that's in the High Court, where a constitutional challenge is now mounted against Section 8.2 of the Tribunal Act, which is in fact the section that the applicant, SIU, is relying on in this application. Both parties, or all the parties, were asked to address me on the issue. And I don't intend repeating all of it, it's all on record. But basically, Mr. Nlukai Toby indicated that the challenge is now also against Section 8.2, and the issue to be decided is the powers of the tribunal to issue the kind of orders that are envisaged in this application. Mr. Musani, for the applicant, also addressed and indicated that he was hard-pressed to challenge what was put forward, and he's hard-pressed not to agree with the respondents who've mounted this challenge, as it is his view that energies and resources should actually be concentrated on that challenge at this point, and that the current application that we're busy with should be put on hold or postponed pending the finalization of that constitutional challenge. Mr. Khoza was in agreement with what Mr. Nlukaitobi had submitted and said he does not object to either the constitutional challenge nor the postponement of the matter. Cost was his only concern, but that could be sorted out at a later stage. This court is faced with the difficult situation that we're not sitting as a high court. My view is that we are still sitting as a court, but the tribunal, as we all know, operates slightly differently. There is a constitutional challenge, yes. Whether it's going to be successful or not, at this point, nobody knows. It should ordinarily not impede the work of the tribunal. However, my view is that, and I must also reiterate that I have not been privy to the papers in the High Court challenge. I had no opportunity to read them, nor did I see the amendment. While we had taken a break about 10 minutes ago, I noticed an email come through with those papers that was sent to me. But at this point, you know, as we had adjourned for an hour, I didn't think that I should start reading them. It wasn't going to change my view in any event that where there's a constitutional challenge, and particularly in this matter about the manner in which the tribunal can or cannot do things, and for this particular matter, the very section on which the SIU is relying is now under attack. And I must just as an aside say that Section 8.2 is the statutory provision which confers the powers on the tribunal. And basically what the challenge to Section 8.2 is you're challenging the legislation. So that is an important issue. And albeit that one should attempt to finalize the matters before the tribunal as quickly as possible, one must always be alive to the fact that if there's a constitutional challenge which impacts on the manner in which the tribunal has to take its work forward, then I'm of the view that that should be allowed. However, one cannot keep these proceedings in abeyance indefinitely. Both Mr. Nlukaitobi as well as Mr. Nosana have indicated that they will be talking in the next few hours about taking the matter forward, that they will undertake to consult with the Judge President at the High Court where this matter is pending to attempt to expedite it. And I think that they will be well advised to take the necessary steps to ensure that this matter is brought to finality and given a hearing as soon as possible. So in summary, I am at this point going to grant the postponement of the matter pending the finalization of the constitutional challenge in the High Court. I'm also directing the parties to approach the Judge President so that this matter is case managed as closely as possible, with the view to also requesting from the Judge President that it be heard as a semi-urgent matter, so that once all the papers have been filed and the pleadings have closed, so to speak, the matter can be heard without delay. And with regard to costs, I think the costs of this matter will stand over for later adjudication. Okay.
Thank you, my lady. As you please.
Thank you, my lady.
All right. Are there any other issues before we adjourn? No.
Nothing from us.
Thank you. Thank you. Court will adjourn.
Thanks, my lady.